Okay, we'll just wait. Hi, this is Jonathan Lubick. It's Scalar. I'm together with David Cohen from STR, Premier Customs um, consulting firm based out of Washington, D.C., among other places, and together with my partner, Jared Christian from Scalar. And I'm happy that you all are joining on this customs and transfer pricing webinar. And I'm just going to pass it on so that we'll do a presentation, primarily customs with also some transfer pricing involved. Um, and David will take it away, and then there will be some time at the end. If you have questions, please write in the chat and we will collect the questions and ask. Take it away, David.
Great. Thanks, Jonathan. I'm really happy to be with you all today. Thank you for joining. Hope you leave after the next 60 minutes a little bit smarter than you were when we first got together. As Jonathan said, I am an attorney based in Washington, D.C. Our firm, Sandler, Travis, and Rosenberg, is a premier U.S. customs and international trade law firm. We do just U.S. customs and import-export related work. And myself, I have been with you. I was with U.S. Customs 1993 to 1999. I worked in a bunch of different areas, including customs valuation, and have been with Sandler, Travis, and Rosenberg since 1999. I've been advising clients on all sorts of things related to value, transfer price, duty mitigation, customs enforcement issues, free trade programs, and pretty much anything else related to U.S. Customs work. Our firm is a little bit more than we've got about 110 people globally. We have a number of offices around the U.S. and a couple in Asia, in Guangzhou and Hong Kong. And I'm looking forward to sharing some thoughts about the favorite topic of the day, which is the IEEPA tariffs and the corollary to the IEEPA tariffs. Everyone is expecting refunds, and we hope that those come to fruition. And what are the knock-on effects with respect to transfer pricing, and how could we expect or anticipate how U.S. Customs might treat issues when there's a windfall of refunds that come hopefully sooner than later. So with that introduction, I just want to remind everybody, I'm going over some general concepts. This isn't considered legal advice by any stretch, but it's really meant for your general information. I'm happy to kind of continue the dialogue from different topics that might emerge and thoughts that come to you during the course of the webinar. And I look forward to kind of following up and having those discussions and see what we can do to assist. So I'm going to go over a little bit of what's going on with the IEEPA tariffs. I think this is occupying an enormous percentage of our firm's time, and I'm going to give you a little bit of background of the state of the IEEPA court case, and then we'll kind of pivot and transfer it into what the impacts are from a transfer pricing perspective, customs valuation generally. So the biggest issue is making sure you understand with precision what happened in the Supreme Court, and perhaps even more importantly, what didn't happen in the Supreme Court back in February. On February 20th, as the kind of the shot heard around the world, as it were, the U.S. Supreme Court determined that the IEEPA tariffs that were instituted by the president unilaterally were not constitutional. And essentially what the court said in the parsing of its decision was that statute is a delegated power to the executive, to the president. And as we know from American history in high school or even before, that Article 1 legislature, they're the ones under the Constitution that regulate international commerce, unless delegated. And that's the important language. There are a number of tariffs, a number of provisions in the statutes, a number of which we will talk about relating to tariffs, that delegate the power to initiate tariffs against imported articles. Under the IEEPA, the particular statute that the president invoked to levy these so-called reciprocal tariffs back in April, and then before that, in February of last year, what they were nicknamed the fentanyl tariffs against China, Mexico, and Canada. Those tariffs were ultimately determined to be unconstitutional. And the reason is that the IEEPA provision has a number of powers that are enumerated in that statutory language, none of which are the word tariff. So the court agreed in a 6-3 decision that because the statute imposed, or I'm sorry, provided all kinds of powers to regulate trade, it didn't indicate the power to tariff. And accordingly, because the statute went on about all the different powers the president could do, they determined that the Congress must have determined assessing tariffs was not one of those powers under this particular provision. The president was authorized to put quotas in place or to put licensing in place and to do all kinds of things that would regulate trade, but not subject imports to tariffs under that particular provision. So what does it mean? It means that the Supreme Court decided only that the tariffs were unlawful. They didn't decide the specific remedy. So the case went back, kind of like breadcrumbs, back through the court system to the appellate court and then down to the trial court. For tariffs, the trial court is the Court of International Trade. It sits in New York, and it's a court of special jurisdiction. It's just like all of the other federal courts. It's an Article 3 court, but it just hears cases on tariff, on different tariffs and different kinds of customs issues. So that lower court is now going to be addressing the remedy. And the remedy, of course, is that the government is supposed to give back the tariffs. The question still remains whether they will and how will they do it. And so it's important that you understand that the decision to provide the remedy of refunds has not been finally adjudicated. The issue is now before the courts, and we'll get to that in a little bit. But I wanted to make sure that you were aware that in the wake of the Supreme Court decision, what happened next was the president issued an order to stop collecting the IEEPA tariffs consistent with the Supreme Court decision, and then immediately issued a proclamation under a different tariff provision in the statutes, so-called Section 122, to assess a 10% tariff against all imports. So it was just a pivot. The president, said I was ordered to stop collecting the tariffs. I'm stopping the tariffs. But I'm going to use a different authority that specifically allows me to assess a tariff. And this tariff, he had the latitude to go to 15%. He actually just went to 10%. If you were watching the news at that window, a lot of trade experts thought almost that it was a mistake, and in fact, a day or two later, after the 10% tariff was announced by presidential proclamation, the president did threaten to go to the 15% level, but never executed on that promise. So the tariff is still 10%. The tariff is in effect for a finite period of time. It expires in July, and so we will see what happens next. That tariff can only be renewed or extended by congressional approval. The belief is that there's not an appetite to provide an extension, but you don't know until a vote is taken. The other thing that's critical to for importers that we are advising clients daily on is what to do in an effort to make sure you position your company as best as possible to receive a refund. And again, I just want to reiterate the judicial process. What has happened since is that the court, the Supreme Court has remanded the issue for remedy back to the Court of International Trade. The Court of International Trade has, there's been some kind of quirky proceedings that have gone on. And what had happened was that one of the many hundreds of importers that filed before the court made a motion to try to compel and force the issue of the refunds. The court issued an order directing U.S. Customs and the government more broadly to refund the tariffs. What happened subsequently is that the party that brought that case is a company called Atmos Filtration. For whatever reason, they decided to withdraw from the proceedings. I don't know if they didn't have the wherewithal. It became too much of a fight for them to have this kind of notoriety. What happened next was that the court basically pulled another company forward, a company called Euro Parfums, and that company has now become the lead case in terms of the remedy. And again, what happened there was that the court essentially copy and pasted all of the orders directing the government to refund money to the new case. And what happened was that because it was a different plaintiff, that company, or it restarted rather the clock for the government to appeal. So right now, where we stand today is that the government has the opportunity to file an appeal against the order demanding that they refund the IEEPA tariffs. That deadline, that clock restarted when the case was transferred to this new plaintiff. The current deadline is June 6th. So we should know a great deal on if and how the government plans to contest the Supreme Court's decision that the tariffs were unconstitutional, but more specifically, why the remedy, the refund to the importers, why that remedy should be limited in some way. So what's happening in the interim is that the court has been very aggressive in demanding customs to report its status on the development of a process through which importers can receive refunds. And how that has kind of manifested itself in our practice is advising companies on how best to protect their avenues to refunds. And essentially, on the slide, it basically shows you the 3 lanes that are currently open in whole or in material amounts. And what I mean by that is that the 3 lanes are, first, there is a process by which customs, and I'm sure you've read about it as well. I'm hoping you have, if you're an importer or represent importers, but there's a process that customs has stood up referred to as CAPE. It's this Consolidated Administration and Processing of Entries. This did not exist 45 days ago. This is made up from whole cloth. It is a system-driven process through which importers can report entries of merchandise to the government, to U.S. Customs, and lay claim to their refunds of the IEEPA tariffs that were previously paid. Those entries that can be reported are currently being rolled out in phases. So this phase 1, for lack of a better way of saying it, it's the cleanest of the clean entries. There's no other kind of enforcement or revenue issue. These are just entries where goods were imported, tariffs paid, and no adjustments needed. no challenges to their assessment. They're just very clean entries. The government, by their declarations in the courts, suggests that approximately 63% of imports should be eligible to be filed through this CAPE processing, so-called phase one. They've indicated they're going to roll out different phases in the weeks and months ahead to address the balance of the entries so that all importers and with all entry types can avail themselves to refunds. But right now, this is now the 1 week anniversary. It started on the 20th, last Monday, and the general reports have been pretty positive. It's a huge data exercise, as you might imagine. But at a high level, what they're doing is they're accepting these entries from importers that are claiming refunds. They're going to strip out electronically the tariffs that were paid and the tariffs that were paid under IEEPA, and then recalculate the entry, the duties on the particular entry that should have been paid, and then kind of queue up the difference for refunds. Those refunds will likely not issue before the courts have their say and decide whether or not they should go forward. The earliest, or Customs is saying that the earliest refunds are probably going to be in the 60 to 90 day window. So we're looking at sometime this summer, provide the courts and that judicial process doesn't intervene or cause any delay. So we're still watching that very closely. Separate and apart from this CAPE process, that again, it was produced from whole cloth. The other thing is that we've been very diligent in advising clients is that there are statutory deadlines for other avenues of relief that need to be preserved. The administrative protest route that Customs allows under statute, and also potentially filing a court action in the individual importer's name. Customs has a very long and developed history of administrative practice where importers challenge duty assessments through the administrative protest route. It's grounded in their statute, and it's got a whole body of law that's been developed over the last several decades, many decades. The key is that you only have a certain amount of time to file a protest. And some of these terms might not be familiar to all of you, but when you make an entry of merchandise, Customs has a process that's usually done by automation. It can be interrupted by human interference, but generally speaking, on day zero, when you make an import, the process is the process is it takes 10 months until the entry liquidates. That liquidation date begins a new clock. That clock is 180 days during which an importer can challenge the assessment of any aspect of the entry. And so we believe that it's imperative that importers preserve their protest rights and file a protective protest against the assessment of the IEEPA tariffs in the event that the CAPE process kind of falters or falls on its face or somehow doesn't deliver the refunds that people are expecting. And then the other avenue of preserving relief is through the filing of a court case. The court cases, different statute of limitations. For court cases, you have 2 years from the date of the payment of the tariff to file your court action. So the lion's share of the tariffs, or I should say the beginning of the tariffs, started in February of 2025. So that means you have until February of 2027 to file your court action to preserve your claim. We've been watching the docket. We've been filing cases on behalf of some of our clients. The docket, I think, as of last Friday, was somewhere in the 3,700 importers of record that have filed their claims. So again, if you're speaking with companies, you want to make sure they're taking all of these steps to pursue refunds not just one of them, but all of them. And just because you filed a CAPE declaration doesn't mean you should forget about filing an administrative protest. Our metaphor is, when you're running a race and it's 100 meters, you can't stop running at 95 meters. You have to cross the finish line. And that finish line is having money in your account with your refunds. So I alluded to this a short while ago, but this landscape is has a lot of potholes, metaphorically speaking. The president, again, the president has the authority to issue tariffs against imports, against imports where he's specifically delegated to do so. And these are examples. This is kind of what I call the tariff arsenal. I just want people to be mindful that just because there is a decision on the IEEPA case where those are not allowed to be used to place tariffs into place, the president has a lot of different arsenals, and I'll go through in the next few slides on many of the different industries. The big issue is that how much notice and administrative process must be followed before the imposition of tariffs. And so, and again, these sections refer to one or more of the various trade acts over the last several decades. Trade Act of 1974 is probably the most prolific in terms of these section references. So these are what they look like. I mean, just numerically, there's, and I'll go through here under Section 301. These are the tariffs that are currently in place under the authority of Section 301. If you recall, under Trump's first administration, he pursued tariffs against China specifically. And those tariffs under Section 301, the umbrella term that is used is to address unfair trade practices. So the 301 tariffs against China back in 2018 were designed to remedy the unfair trade practice of disrespect for intellectual property. And those tariffs were put in place. President Biden came into office. He didn't take the tariffs away. Tariffs tend to be sticky, and I think that is potentially a problem. If you're in the import world, that there is hope that changes in administration will bring about changes in tariff policy, but oftentimes it's hard to unring the tariff bell. There's also a 301 case. It's being threatened against Nicaragua regarding, they've been on kind of a target, for lack of a better word, for a while. And the 301 tariff is a significant bargaining chip that's in place and ready to be activated at the president's choosing. Other tariffs, again, and this isn't, so this is just more to put on your collective radars. These are tariff investigations under the authority of Section 301 regarding a lot of different industries. The first two are the ones that were initiated a short while ago, and they tend to be kind of the most broad in impact. And then these are typically they're country specific and they're product specific. And so this is just some of the things that are kind of on the radar. Section 232 is to remedy national security concerns. And so this is what these look like: steel, aluminum, copper. The metal imports community has been up in arms for years now because of the tariffs that have been put in place. There's one just recently on pharmaceuticals, and so these, if you're in these businesses, your companies should be well aware of their impact. And then here are just a bunch. Again, this is more for general information. These are particular industries that the president has targeted under the auspices of the concerns over national security. And as promised, we're going to pivot to what are the implications. So what happens is that for transfer pricing and customs valuation, what happens here is that a lot of companies are eyeing a huge windfall. They've been paying tariffs for the last, from February of 25 to February of 26, and now they're standing at the precipice of potentially a huge refund. And so what does it mean? So I'm going to give you a brief primer on customs value. And what happens is that the customs value concept is generally, this is parroting the statutory language, that basically it's the value for customs purposes is the price paid or payable plus certain additions. And there is a general understanding from customs court cases that all monies that are paid by the buyer to the seller are presumed to be part of dutiable value unless you can just distinguish the payments to be something other than for the goods. Customs has a long history in its valuation practice of evaluating related parties. So many of the transactions for imports, as you are well aware, are between related parties. And so customs has developed kind of a kissing cousin, if you will, to the IRS provisions, but they're very independent in the sense that they do make sure to kind of stake their claim that their related party test is different than the Internal Revenue Service. I think the biggest thing is that that you have to keep track of for customs is that customs works in a transactional environment and the IRS works kind of in an overall period environment. So, while transfer price adjustments tend to address comparable profits for periods of time, customs has to value and collect duty on particular transactions. But they're not naive to the fact that importers do import pursuant to transfer price policies, and so I wanted to kind of move into that arena. What happens,
David?
Yeah,
1 minute. Can I just want to just before you go into where you're going to go into, a long time ago there was all this talk of customs and transfer pricing starting to share information and work together, et cetera, et cetera, et cetera. I think customs then started to modify things so that they could show that they're dealing with related parties and in a way consistent also with transfer pricing. But I want to ask you, because this is going to be important for what you talked about in refunds, how much is there really sharing of information? How much do you really see? Are they really working together? Are they going to now because of the refunds?
I think at one time, even dating back to my days, 93 to 99, when I was at customs, there was talk about that. I think it's never really materialized. To the best of our knowledge, it hasn't. And as you may be well aware, that the IRS has kind of been gutted a bit of late. And so, that sharing of information is not manifesting itself in anything that I have seen in my practice at all. I think it's still aspirational. I think they think that you can stroke a few buttons on a keyboard and all of this connectivity can happen, but I just haven't seen it in my practice. But so it generally, again, this slide is really just intended to kind of give you a little bit of the map that customs uses. Their statute sets forth, or really this is set forth in the regulations, where in establishing that the relationship does not influence the price for customs purposes, they usually lean into the fact that they've examined the relationship before, whether the buyer can demonstrate that they buy and sell product in a way that is consistent with normal pricing practices. So this kind of conjures up in transfer pricing world, benchmarking studies and things like that, and using that as defense. And customs is open to that information being provided for defensive related party prices. And then they often use what's set forth in number 3 is a comparative profit for for comparable periods of time between the buyer and the seller. And the thought here, as interpreted by customs rulings, is that if the seller and the buyer are earning comparable profit, then that must mean the relationship doesn't influence the price. And so that's kind of their logic in how they evolve to interpreting the acceptability of related party pricing. The other thing that or I should say that the thing that we're trying to kind of hone in on is when there is a windfall, how does that impact customs value? So I think the normal expectation is that a U.S. entity buys from a related offshore company. The U.S. entity may very well be kind of a limited risk type distributor of product and typically remits excess profit to the parent company that it's trading with offshore. When that U.S. distributor receives a huge windfall, that offshore parent company will likely want those monies repatriated to the parent. And the question is, does that value, does that payment, is it included as part of customs value? And we think, and again, and this is where we'll go into what we believe.
Go back there though, because I want to deal with that before too. But
please.
So I want to, so from the transfer pricing IRS perspective and everything that David's saying is that refund pertaining to customs value. So I think this is everything that we're talking about now happened in 2025. Transfer pricing documentation for the U.S. perspective is supposed to be documenting that previous year, and those who had customs issues, their profits potentially were being affected. And we don't even know how the comparables that David was talking about benchmarking, how their 1 year numbers were being affected yet. But I think what it means is everyone has to go back and reassess their intercompany contracts. If you had a force majeure clause, maybe you now need to make a customs clause, because the refunds, from what I'm hearing from David talking, aren't necessarily going to happen in 2026. They may not even happen in 2027 or 2028. And so it's time to probably put in some sort of issue between the U.S. entity and its foreign entity who was selling to it, or where there were customs issues, that refunds are refunds or losses that accrue, just like losses from a customs perspective, is the risk of the entrepreneur, the foreign entity. And so that money could go back, sort of like foreign exchange gains and losses, where oftentimes all those gains or losses were the risk of the foreign entity or the U.S. entity, whoever it is who was the entrepreneur. And you can effectively, the IRS won't like this, but at least you have contractually set up a way of moving that money back without even dealing with legally, without even dealing with customs, without making some sort of other charge, not then having to make a management fee or other types of charges. You have it already done legally. And I think that's still going to be something that's going to be somewhat controversial perhaps, but at least in your intercompany contract, you have something set out saying that those refunds for past years are to the benefit of not the U.S. lower risk entity, as David was saying.
Also remind everyone on the webinar too, if you do have questions, there is a chat box, and you can use that to provide questions if you have any, and we'll try to address as many of those as we can at the end. So I apologize for not mentioning that at the outset. So if you do have questions, feel free to use that function. I wanted to pivot a little bit and talk about the notion of transfer price policies and adjustments and customs. Like I was saying before, customs was well aware, and again, many of the imports are imported pursuant to intercompany transfer price policies. And years ago, literally dating back into the 90s, importers always struggled with how to properly report adjustments that were made at period end for transfer price. And what customs had historically determined was kind of a heads I win, tails you lose type of policy. So they interpreted the value statute to say that if you made a supplemental payment to the seller of the merchandise, they wanted to know about it and they wanted to collect duty on it. If the buyer, under a transfer price adjustment policy, was paid more from the seller, and the flow was the opposite direction, customs determined that that was a rebate. And because it was made post importation, they just didn't care about it. They didn't want to refund money. Again, therefore the heads I win, tails you lose kind of approach. They always wanted to capture the value and pay duty on it. Well, this became kind of tiresome, and it just didn't make sense. And so, again, decades ago, they started to utilize a program called reconciliation, and they had set forth in rulings in the past kind of some criteria. And again, these are just kind of baseline criteria for transfer price adjustment, all the transfer price policies. They have to be in writing, and et cetera. And so these requirements kind of served as the springboard for this reconciliation process. So now, in today's world, what happens regularly is that importers will electronically flag their entries and basically say to customs in an electronic way, I'm using my best information to declare entry at time when I introduce the goods to the United States, but there are attributes of value that I might not know, but I promise to report them at a later date. These, for purposes of today's discussion, these are for transfer price adjustments, up or down. You can either get monies refunded or you have an additional liability. We help companies report transfer price adjustments day in and day out. We have a team of 7 former US Customs auditors on our team that do this work in support of clients who are using transfer price. In addition, there are additions to value that might not be known fully as well. So it's not just transfer price that is the sole issue that's being reported, but it is frequently the main driver. So there is a policy in place to report these adjustments. And again, this is just kind of the same thing. The process is essentially, again, you make an entry, you flag it electronically. You have 21 months from the date of the earliest entry to report your information to customs, your true up, if you will. The reason why they give so much time is that most companies will take a fiscal year. They'll do whatever adjustments that are done. And then at the close of their fiscal year, they essentially have a 9-month window that customs affords importers to report their adjustments. And so this has worked out quite well. I mean, I think most companies that we deal with that are doing transfer price adjustments use reconciliation. So when we were preparing for the webinar, one of the challenges that we wanted to try to answer was what do we think customs will do when these refunds come to fruition and there are monies that are being passed from US importer to offshore related entity. And so we dug up basically some old customs rulings and court cases that talk about these issues. And this Chrysler case, I think, is very emblematic of how customs tries to deal with these issues. Essentially, what happened in this court case was that the Chrysler Corporation contracted with an overseas supplier of engines, and the producer had to make significant capital investment to produce the engines. And written into their contract were provisions that if Chrysler didn't purchase the requisite number of engines, some minimum level, that there would be payments to kind of recapture the significant capital expense. Of course, Chrysler didn't buy enough of the product pursuant to the minimums. They made a significant payment to the French supplier. When those goods came in, US Customs wanted to collect duty because they said payment by the buyer to the seller, that's part of the price of the goods, and we want the duty on this additional payment. Chrysler fought back and ultimately agreed. I'm sorry, the court ultimately agreed with Chrysler, and they determined that those payments were essentially cancellation payments. They were not payments made for the goods. They were specifically payments not to have goods produced. And so ultimately, despite Customs' best efforts to litigate the issue, Chrysler prevailed, and the court said, if you can demonstrate that there's a payment that's not related to the goods, then they're not subject to the duty. And so that is where we think Customs likely would go with kind of a large refund of IEEPA tariffs in some later period. Another issue that surfaced was in a Customs headquarters ruling. Again, this is very dated back, you can see the date from 1999. What happened here was that an importer challenged the assessment of a particular tariff rate and challenged it through to the courts and ultimately won a decisive victory. Their product was just determined to be subject to a much lower rate. They got a windfall refund and they remitted a portion of that refund to its supplier. In this case, they were unrelated, but Customs determined that the payment was not for imported product, it was really for goodwill. And so it will be interesting to see how US Customs determines what will happen. And I think one of the challenges that we foresee is connectivity. So, if you got a $1 million refund for IEEPA and you paid $1 million to your overseas parent company, maybe that is more the best case where you can say it's just a repatriation of the tariffs. But if you repatriate more or less, maybe less isn't so problematic. If you repatriate more, maybe the Customs won't be convinced that it's singularly IEEPA related. And so, we anticipate this to be kind of a knock-on issue or impact of, and we're not quite sure how Customs will treat it. And I think the facts for particular cases will be really important in how those issues get worked out. But
I want to add. I want to add in, David, that when we were talking about redoing the intercompany contract, I think these two cases, that's what we were talking about beforehand too, right? There may be things that you can help on that intercompany contract that can have some sort of customs type basis for that gives some sort of legal justification for not based on those cases already in a written contract or an amended contract that will give a little more gist to the ability to not have that refund pertaining customizable.
Yeah, I think the big concern is that, one, the government is disappointed that over the prospect that they might be refunding the tariff. And this avenue of, if there is repatriation from the US importer to a related parent overseas, that it's another bite at the apple for the government, for the US government, to try to collect the tariff on those additional payments as part of value. So we will see how that plays out. It's really a little bit early in the process, but I think I don't know if Jonathan, I don't know if you had anything else to share. This is our respective contact information, and I don't know if questions had surfaced in the chat, but I'll ask Jonathan if you had any other remarks, and then turn it over.
No, there was one question: is that everyone who participated is will be sending you the presentation. And David, as David said, he's really the go-to guy. And I know I've worked a lot with him. There are all sorts of other customs issues that we talked about. There's this idea of first sale rule that he's dealing with me all the time on, and all sorts of things. I've known David for a long time, and it's only recently that we really started to work together, but that's because of what went on. We were working from time to time together, and he's very, very, he's reachable, and he's very, very personable, and will listen to you and try to make things work, and to the best he can within the framework of what can work. So thank you, David. I want to thank you for taking the time to present to all of us.
My pleasure.
That's it, Jared. I think there are no questions, correct?
No, there's one that just came through. Can you share more details on the first sale taxation?
There you go.
First sale. There you go. First sale is, I can give you a time lapse. It's a valuation concept that is a duty mitigation strategy. It was achieved, or the result of, a court case that our firm actually litigated back in 1988. And essentially what the proposition stands for is that if there are at least 3 parties and 2 bona fide sales, the most typical being a factory to a trading company to an importer, the default value for US Customs is the last sale. In that simple example, the trading company price to the US importer. What the first sale value accomplishes is that in properly constructed structures, Customs allows you to use the factory price to the trading company, which is obviously a lower price than the price from the trading company to the importer, to serve as the basis for the duty calculation for purposes of Customs value. This is an approach that has been very popular since inception. It got famously popular in 2018 and ever since, largely because of the China tariffs that were implemented starting in 2018. And then it got a dose of kind of hyperdrive in 2025 because of all of the IEEPA tariffs. And so, now that the IEEPA tariffs have gone away, these so-called, the Section 122 tariffs are here. They're lower, but they're still impactful. And so, companies, and again, it's a valuation construct, so they're kind of agnostic to what the product is. It's just a question of properly structuring the transactions to minimize the duty impact, regardless of what it is that you're making. Products that attract higher duty rates, can attract higher savings, but really any product is fair game to evaluate for potential savings.
Did you see that other question? in the webinar chat? Want me to read it? It's the second one from
Yeah,
Chrissy.
please. I'm
No,
not
you're
going
okay.
off camera.
Yeah.
Yeah,
And this
please
may be
do.
more Jonathan. Jonathan says regarding transfer pricing, says that we recalculate transfer pricing and we need to pay additional due to the cost. My question is, given the circumstances, the tariffs were, I think they're saying they were considered illegal from 25, but is it necessary to pay for this difference? Christy, if I missed that question, feel free to clarify. Jonathan, you're on mute. Jonathan, you're on mute.
Sorry, I think right now you need to behave according to appropriate transfer pricing practices and record the profits or or pay the prices that were being paid without duties. You'll be paying additional duties, but then you have to accord your transfer pricing to be within the arm's length right now. The big issue is what we're talking about is if 3 years from now, if you were supposed to be earning $1,000 each year in the United States, and all of a sudden you get another $1,000 refund. So now, according to policy, now you're at $2,000, and that's 2 times as much as you're supposed to earn. What do I do with that additional $2,000? And does it mean that in that year now I charge twice the price? But now there are duties on that, and then you set a standard for duties that's much higher than it was before. I don't know that that's right. Or does that additional $1,000 somehow get sent back in some contractually or in some other way, shape, or form to the entity who was selling the goods to the U.S.?
I would add on the custom side, the question is really putting their finger on a really awkward situation that we don't yet have an answer to. And it's the following fact pattern. You've entered merchandise all year in 2025. You've flagged your entries for reconciliation. You've had a transfer price adjustment. The problem now is that if you go and you try to report the adjustments, the systems in customs attract the tariff and they're frozen in place at the time of the import. So what happens is if you have $1 million adjustment in price and you've paid your foreign seller and you try to report that to customs through reconciliation, you are obligated to pay the IEEPA tariff on the increase. And of course, you don't want to pay the IEEPA tariff on the increase because the IEEPA tariffs are unlawful. And customs systems, and this is why there's different phases of the refund process that we talked about, the CAPE process. Customs is trying to figure out how to program around this issue. And then similarly, if your parent refunded you $1 million in 2025, if you try to report that adjustment downward and get a refund, customs won't refund the money, not yet. And so this is a big issue. And again, I'm not sure if the questioner was trying to put the finger on that, but that is a to be continued and a well-known problem that we're trying to help companies navigate. But right now we're kind of in a holding pattern because it's really created kind of a programming nightmare for customs to kind of remedy that situation.
Okay, we got another question here. Chrissy said, okay. So Chrissy said, just to follow up on that real quick before I get to Luigi, thank you. So this will be open for a while. The safe side is to pay with the tariff calculations and declare that price.
I would say we should talk about that. I am not a huge fan. I'm not a huge fan of paying the tariff. I think there are a couple other avenues that I think they're a little technical for right now, but there are some other avenues that we're kind of exploring with companies to try to avoid them having to kind of prepay the tariff for a period of time in which the tariffs weren't in effect, and then only to chase the refunds. And it's not clear if customs is actually even accepting the payments. So I think that's a better question to go deeper offline.
Wonderful. Yeah. So feel free to follow up with us on that, Christy, and we can do the same. Luigi said, can a post-importation transfer pricing adjustment to goods that were subject to the unlawful tariffs trigger section 1059A disallowance?
The 1059A issue is, it's a IRS issue. It leaves kind of my world and goes into the tax and accounting treatment. I know on 1059A, Customs has issued rulings, referencing 1059A and readily identifying reasons why customs value and your COGS, your cost of goods sold, and your carrying costs can be different, and it's appropriate for them to be different. And so, again, that those are, like I said, in those other contexts, the facts matter. So, I mean, I think that too is a little bit granular for kind of a general response, but at a high level, Customs and the IRS generally know that customs value and TP value can be different for appropriate reasons.
All right. I want to thank everybody for participating. We really appreciate you all participating. I'm sure you did, but I hope you were edified. And David, again, I want to thank you. Jared, thank you. And again, the presentation will come out to everybody. Thank you.
Thank you for having me. I hope you found it informative, and feel free to reach out. And then I guess just in closing too, our firm has these different avenues for education. Feel free if you'd like to navigate to our website. We do a lot of different training on customs issues, and happy to chat if you have specific issues that we can help.
That's it. Good. Bye-bye, everybody.
Goodbye.